very much, Council, for letting Commercial Wharf come and speak with you tonight. As some of you may be aware, we have legislation that Representative Aaron Monkowitz filed on behalf of the first floor unit owners. A request for determination was filed against the building about 8 years ago that Michael will talk about, questioning the legality of the first floor units. They were converted with a minor modification issued to a developer in 2004, 2005. The units were transacted numerous times, numerous times to various families, and we have a lot of folks that are living there now. We're a little bit in limbo, and I'm going to let Leon, our attorney, explain all that to you. Thank you.
Thanks. Mr. President, members of the council, Michael Leon from Lauder McLennan Fish on Seaport Boulevard. As Cheryl indicated, this is a very, very complicated matter. It would probably take us an hour to go through this very complicated history of the matter that rests between the condominium association, individual unit owners, the Department of Environmental Protection, and now the Attorney General's office. But let me just try to take a few minutes and give you a general idea of what's happened over the last 20 years, how this came about, and where we are today, and why the special bill that was prepared by Representative Monkowitz is so important and critical to both the association and particularly to our clients, who we represent 5 of the residential unit owners on the ground floor who would be displaced if we don't take action. As Cheryl indicated, this is a building that's been there for a long, long time, obviously over 200 years. And back when Boston waterfront, particularly the North End waterfront, was in significant decline back in the 1960s, the Boston Redevelopment Authority and the City of Boston developed a redevelopment plan. And one of the major goals of the redevelopment plan in the 1960s was to preserve and protect the unique architectural and historical significance of the structures along the wharfs, and to revive the neighborhood by not only promoting the redevelopment of that area, but also reintroducing residential uses along the waterfront as part of the redevelopment of the entire North End. And to that end, the Redevelopment Authority, Boston Redevelopment Authority, encouraged redevelopment plans for each of the buildings to try to protect and develop mixed-use buildings. Those are buildings that would include both residential, commercial, and in some cases office use, and that's what was proposed and approved in the 1970s. Now, 2020 hindsight is perfect. I'm going to talk for just 2 minutes about what's called the Waterfront Act in Massachusetts, Chapter 91. I know that there are probably many people here who heard about the application of Chapter 91 to a lot of development projects on Atlantic Avenue. But basically, the Waterfront Act and Chapter 91 regulations that now exist are extremely complicated to begin with. And they have different applicability to properties that are in municipal harbor plans. This property is not in a municipal harbor plan. This project and property is subject to the general Chapter 91 regulations in the Commonwealth of Massachusetts. And those regulations provide that if the project has been, if it pre-exists 1984, and there have been no changes in use or changes of use, then they are permitted to continue those uses in perpetuity. Now, this is a building that was specifically redeveloped in accordance with the redevelopment plan and rehabilitation plan to contain a mix of these uses. In 1984, the department began to question whether or not there had been any changes in that building, knowing that as a 5-story structure was comprised of residential, office, effectively residential and office use. I don't think there was any, I'll call it retail or commercial use, but office use and residential use. And so the developer at that time went to the Department of Environmental Protection, as Cheryl said, and they went through what was called a minor modification request. And in that request, the developer at that time proposed to convert some of the ground floor uses, which were used for office use. I think it was a magazine, Inc. magazine was located there in the 1980s, and proposed to convert the office uses to residential uses. And the Department of Environmental Protection at that point issued what's called a minor modification, which is effectively an approval for the conversion. The reason being that this was a mixed-use building, it would remain a mixed-use building, and in fact, the uses were still going to remain facilities of private tenancy. It's important to recognize that under the redevelopment plan and under the Chapter 91 program, public access to the wharf was required. It is required, and it will always be a covenant and a responsibility of the wharf owners of the condominium association to remain open and available to the public, at least insofar as one can go around in the open space to reach the waterfront and also to serve the public interest in fishing, fouling, and navigation. And nothing that is being proposed, that I'm going to describe to you in a moment, is going to change the fundamental commitment to preserve and protect public access to commercial water. What happened, though, about 5 or 6 years ago, as Cheryl indicated, was that there was a dispute with one of the abutting property owners, which led to a petition to the Department of Environmental Protection. And in that petition, the abutter indicated that they thought that there had been, quote, a change of use that would be not permitted under the regulations and which would require that the building be relicensed under Chapter 91. Now, as I said, in Massachusetts and in Boston, there are many uses that predate the 1984 cutoff threshold of the Chapter 91 regulations. Nevertheless, the department looked at this and they said, well, has there been any change in use? One might say, no, it was permitted as a mixed-use building, whether or not a particular unit went from residence to an office or an office to residence, the uses, which fall under the category of facilities of private tenancy, remain facilities of private tenancy. And the deeds for this, the master condominium deed does specifically provide that all of the uses in that building, all of the units in that building can be used for residential, office, or commercial use. Nevertheless, the department, without conducting a full hearing, decided that indeed there had been some unspecified change of use that would require this project, this building, to be licensed. And the implications of that are that if it were to be newly licensed, one would have to comply with the current Chapter 91 regulations, which would prevent ground floor facilities of private tenancy. I think many know that if you're within the jurisdiction of Chapter 91, within a certain setback from the water's edge, you have to have facilities of public accommodation. So now you have dozens of property owners who bought those units in the 1980s when the DEP said you may use them for residential use, now facing the prospect of having to have the building licensed and by doing so be prohibited from using their homes for residential purpose. To make the matter more odd, bizarre, when the developer obtained the approval from DEP to specifically and expressly use their ground floor units for residential purposes, they put restrictions in each condominium deed that restricted to only be used for residential use, not commercial and industrial. So what you have now, and the clients that I represent on the first floor, have deeds which say that they are only permitted to use those condominium units for residential use, and the prospect of getting a new license for the whole building that would prohibit their use for residential purposes. Very bizarre outcome. When the decision from the department was finally issued, the condominium association filed an appeal to the Superior Court, and we, on behalf of the unit owners, participated and intervened in that proceeding to join that litigation in the Superior Court. Last year, the Superior Court judge overturned the DEP decision. So one would think, finally some justice is served. The judges in Massachusetts have realized that the Department of Environmental Protection made a very serious and grave mistake, misunderstanding and misinterpreting the rules and the regulations, because our clients and all of the ground floor users are, in our opinion, protected by those grandfather rights that are contained in the Chapter 91 regulations, and they should be permitted to stay there. We frankly thought that with the decision of the Superior Court, this was going to be resolved, it was going to be sent back to the DEP, who would realize the error that the court identified, and the court was very sympathetic to the property owners on the ground floor. Nevertheless, earlier this year, we found that although it looked like the Department of Environmental Protection was simply going to handle this case and resolve it, the Attorney General's office decided to bring this action and elevate it on appeal to the Court of Appeals. So what we're facing now is yet more litigation for the association and for the individual unit owners to preserve and protect their rights to stay in their homes. Now, the clients that we represent have been there for decades. In some cases, they've invested their life savings. One client and her son live there. This is their residence. Others have planned on retiring there and leaving the property to others, and yet the department has made it quite clear in the course of the litigation that A, not only are they uninterested in resolving this by settlement, but B, that it would be their intent to ensure that our clients vacate their units and convert them to something other than residential units. Now, I want to mention something about the Harbor Walk, which is, I think, very important, and I think it's been the topic of a lot of conversation. In 2004, when the DEP issued this so-called minor modification authorizing the change of uses from some units from commercial office space to residential space, the developer promised to build a harbor walk along the south edge of the wharf. Surprisingly, the department did not say, well, the reason that we're not going to respect and honor this minor modification approval that we granted in 2004 was because the harbor walk was not built by the developer. The department didn't even go there. The association and the unit owners have committed from day one to build the harbor walk, notwithstanding the fact they were not the ones that were required to build the harbor walk. And let's just push all of that aside. The point I'm trying to make is that if someone were to argue that the quid pro quo or the public benefit to be obtained from allowing the modification of uses from an office use to a residential use was the development of a harbor walk, the harbor walk requirement would be fulfilled. We've made that absolutely clear. The association is filing a notice of intent with the Conservation Commission in Boston to construct the harbor walk in the location that was proposed to be built. In fact, on the wharf itself, but it had not moved the department. So what we really have is a frankly impenetrable issue in my mind, and I've been doing this for almost 40 years, practicing under the Chapter 91 rules, and have never confronted a situation so inequitable and so unfair as to basically have the Commonwealth say, you know what, we believe that although you've been grandfathered and had been approved in 2004, we now think for reasons that we, the department, decide are appropriate, that you should convert your uses to non-residential uses, in fact, to convert them to facilities of public accommodation. As a result of this quandary that everybody's been facing for a while, Representative Nikowitz has drafted some special legislation that would correct the direction that the Commonwealth has been taking in this litigation. It's basically House Bill 833, which is docket number 3586. Now, let me tell you a little bit about what the bill does and what it doesn't do. First, what it doesn't do, it does not affect the responsibility and the obligations to maintain public access on the wharf. It also doesn't change property interests with respect to parking on the wharf. The parking that's currently permitted on the wharf was permitted with a redevelopment plan, the redevelopment project approval from the City of Boston, and is permitted. I mean, after all, in the 1970s, when that building was rehabilitated and used for office and residential, at the time there was a significant demand for parking for the unit owners in that property. So the wharf does have, and will always have, parking rights on the surface of it, but that parking has to accommodate public access. And it does not affect or bar or restrict the responsibility that we have to build the harbor walk. So the harbor walk will be built, public access will be maintained, and I would argue improved because you're going to actually have a harbor walk. But what it does do is, in very simple terms, say that when the Commonwealth of Massachusetts approved the redevelopment plan in 1974, and when the City of Boston subsequently approved the specific plan for the rehabilitation of that building, the legislature, in addition, authorizes the current uses in that building under Chapter 91. Now, up until 1973, the legislature granted Chapter 91 licenses. It wasn't the Department of Public Works, it wasn't the Department of Environmental Protection. The legislature did this. And what this really does is revert back to the authority that the legislature has to basically approve actions under Chapter 91. So I want to make it clear that this is not effectively an exclusion or exemption from Chapter 91. What we're really trying to do here is to reaffirm that this redevelopment plan that was approved by the legislature in the 1970s, contemplating a mixed use of residential and office uses out there, was intended to be determinative on how that project would be used, how that property was to be used. And by so doing, it obviously protects and preserves the private property interests of the residents that currently reside on the wharf. And that's really all it does. So we'd like to solicit support for this bill. We think it's a very surgical action that's being taken. It's been being done only to preserve and protect the existing ground floor uses in that building. Has no other implications with respect to redevelopment anywhere else, even redevelopment of the wharf entirely. It simply has the effect of saying that those people who reside on that ground floor, who bought those units with deed restrictions that they can only use them for residential purposes, shall be protected and are authorized to stay there and not have to sell their homes, not have to vacate their homes and convert those uses to other uses. So that's what it does. We would really greatly appreciate the council's consideration to supporting this special legislation and protect the interests of the residents of the North End. So with that, I'm happy to answer any questions or explain some pretty inexplicable things.
Yeah, so open it up for questions from the council. Just to be clear, actually, so the specific legislation that you're seeking is just, I mean, exempting, not exempting, but just granting permission for or just clarifying the use of commercial wharf, not necessarily exempting any from Chapter 91.
We're not exempting it, we're basically declaring that it is authorized under Chapter 91, those specific existing uses, which is really not different than the Chapter 91 regulatory protection, because the Chapter 91 regulatory protection says that any use which predated 1984 is permitted to continue those uses. You know, and these were uses that were there. I mean, if you look at Lewis Wharf and if you look at Union Wharf, all of those projects are mixed-use projects. And whether or not someone on the second floor or the first floor, you know, you might own, in fact, if you really want to get into an absurd interpretation of this, there's a lot of people who have home businesses. They live and work in their same space, this live-work space. If you chose to convert your residence to an office and residence, is that a change of use? Obviously, we don't think so. If someone moved from, if they had a home office on, or an office on the second floor, because this is not just relevant to the first floor, but the department viewed this as a building-wide potential change, that if someone in unit 31 moved their office from 31 to 33 and swapped it with a residence for a better view, that would be a change of use in the eyes of the DEP in this case, which is an absurd interpretation. And there's no other, of all the projects that I work on Chapter 91, along the Boston waterfront, this is the single and only instance where I've seen any suggestion by the DEP that anything like that would constitute an actionable change of use, particularly where, in this case, in 2004, the DEP issued a specific authorization, so-called minor modification, which is effectively like a license, and that's what everybody who pays real estate in Massachusetts recognizes. A minor modification, although not recorded, serves as a definitive determination by the department that the proposed action is authorized by the company. So it's an unusual situation.
Who's the abutter who petitioned DEP?
It was Boston Yacht Haven, the operator of the frankly illegal hotel, which has been out there, and the marina. And the hotel is not licensed at all.
What's in it for the DEP? Why are they calling it this? Why is this a thing for them?
Pardon?
Why is the DEP like pushing this through? What's in it for them? Like, what's the motivation here? Why would they want to displace people?
I wish I could explain why. I mean, as I said, I've been doing Chapter 91 work for almost 40 years. I've worked with the department dozens of times along the entire Boston and Massachusetts waterfront. I've never seen the department express this kind of position. And there's no way. We've attempted to participate in settlement negotiations through the Attorney General's office. The department, frankly, does not respond to, well, aren't we going to simply fulfill the obligation to build the Harbor Walk, and wouldn't that have fulfilled the requirements of the minor modification? And the position we've taken in response is simply, we think if we determine that you need a license, that you need a license. Frankly, they were so disingenuous that in conversations with the Attorney General's office, the Attorney General told the court, we're not going to prejudge what happens in the licensing process, which of course is a pretty bizarre statement, because I can certainly tell you that if the project had to be relicensed to comply with the current Chapter 91 regulations without the benefit of the grandfather provisions, that all of the ground floor units would have to be converted unless the department chose to grant a variance, which is unusual. But I will tell you that the department has, in some instances, granted use variances to allow people to stay in their homes. So in the last 20 years, the department has granted about 15 variances up and down the coastline to permit people who live on the ground floor of residences, of buildings, to stay in their homes to be able to maintain that use in perpetuity. Sometimes and often with a commitment to build or provide some public access. The department in this case has said, well, we don't really think that this would be eligible for a variance. We want to litigate this case. We want to basically prove that we've got the power to determine whether you have a minor modification or not, that we have the power to determine that there's a change of use and you have to become subject to a new license. Now, we all know new construction and new development is subject to the Chapter 91 rules and the Municipal Harbor Plan rules. What's bizarre is to take a building that's been there for 165 years, residents have been there, the redevelopment plan was approved in the 1970s, and the rehabilitation plan in the early 80s. These people have lived there since the 1980s, and say, we're going to change, we're going to basically eliminate the grandfather provision, because the possibility exists that one person in a, how many units are there? 94 units. If one person in one unit decided to do something that was not authorized by Chapter 91, that the other 93 unit owners would then become subject to the new rules. It's a very, very, very bizarre interpretation. And I wish I could answer your question. What motivates them to kick people out of their homes?
Are there upcoming projects around that area where it would make sense to them?
No. To be honest with you, yes, there are upcoming projects. There's a proposal that's been circulating around by Tavistock to build a hotel complex there. I'm not going to speculate, but I would argue that the lawsuit and the issue that I'm describing that this special legislation addresses would not have any impact on the Tavistock project. It just, they're apples and oranges. That Tavistock project has got substantial hurdles, I'll put it that way generously. This legislation would have, doesn't even touch the Tavistock parcels. It simply says that the existing structure on Commercial Wharf, the existing residential uses are protected and preserved, and that's all it does. So we're not out to expand the benefit.
I'm just, what other public access is, I mean, I know you don't technically have a harbor walk that's dedicated, but you can still get around the whole building and access to others. What other public access are there for the building itself, if any?
There really is just the wharf surface
Yeah.
is subject to the public's rights of access under Chapter 91.
Right.
So
Which you currently
right now, which it currently has. And so it
And on the north
doesn't,
side, there's a temporary harbor walk about 4 or 5 feet on the north side of the so that
Oh, yeah.
Concom asked us to do a while ago.
but not
Maybe-
much.
No, it's small, but
That's
it's there, we push the
Yeah,
parking spaces
but I mean, it's
back.
there. Right?
Oh, yeah, people can access the Wharf 21 today.
Yeah.
The harbor walk that's going to be proposed, which is going to be going before the Conservation Commission, is going to be 8 feet wide. It's going to be
On our lane.
on the wharf, on the solid land of the wharf. Basically will involve squeezing in the harbor walk there, trying to protect as many of the parking spaces that exist, and delineate a very, a traditional harbor walk all the way out. I mean, we certainly understand that Yacht Haven operators were not that interested in having harbor walk at the time all the way around property, which I think that they envisioned as being less public in that respect. It's a water-dependent use, at least the marina aspect is a water-dependent use. I'm not going to suggest to you, frankly, that the hotel is a water-dependent use. It's not. But at least with respect to the harbor walk, there were certainly some indications that there was not a lot of excitement about having a harbor walk located near that marina. But that's a different issue. I'm here just to suggest that the concern we have tonight is to protect and preserve the residential interests of those people who are on the ground floor.
So real quick too, I'm sorry, I was just, it says that you request community support, but then you also want us to take a vote on this tonight too, as well? Is that what
We
the-
would love an endorsement from the council in support of Representative Nichowitz's bill. I mean, Representative Nichowitz has been truly committed to helping to correct this issue. It's been incredibly frustrating that it was necessary to actually propose to have the legislature step in to correct the problem. But what's unusual about this, and oftentimes people might try to get to do an end run around the Chapter 91 rules, to build something new. This is the first and only time that I've ever seen that someone feels compelled to draft legislation to protect an existing use, an existing residential use, the way that this is intended to do. It's basically to preserve and protect the grandfather authorization that we all understood was a basic element of the Chapter 91 program. And that's really all it seeks to do. So it would be terrific to have a letter of support for that legislation. And we're happy to work with you to do something that would further that.
So we were, well, first of all, does anyone have anything they would like to add or speak on for this? Yes?
I'm a first floor resident owner of Commercial Wharf, and I'm actually pretty familiar with Chapter 91, not through this, but I'm an assistant harbor master, so I've worked with the DEP. To answer your question, I think, honestly, this is, doesn't make any sense to me. I think it's, and I've been involved in this for the since I moved into Commercial Wharf. I was really surprised. I bought this residence, I'm a senior citizen, my wife's a senior citizen, this is our investment, we live there, and it boggles my mind that the DEP is taking this stance, and I think part of it is going back with several administrations, the DEP that have changed. I think this is one of these things where somebody's trying to save face. And that's the way it looks to me from my standpoint. So I would appreciate the support, because I think this is probably the only way other than further litigation. And the Commercial Wharf and the residents there, we spent a lot of time and effort litigating this. And I was at the Superior Court hearing, and the judge said to DEP, isn't this kind of ridiculous? To kind of go back on something that's what I heard. And the DEP said, the attorney for the DEP said, we don't have any intention of kicking people out of their, I believe I heard that. But this doesn't make sense when the Attorney General picks this up and says, nothing that happened in the past really counts. So.
Disingenuous. The comment was disingenuous to the court.
Also, you have a developer who made a lot of money by flipping those units when he got the minor modification and left without going to the harbor walker, putting the money in escrow according to the agreement they signed with the DEP.
When he was speaking, I was remembering a lot of different things, and I would be in full agreement with saving these people's lives.
Thank you.
I can't contain myself. I think it's outrageous, the position that the DEP is taking. Do they say they're not bound by the determination of a minor modification? And if they do say that, don't they say it with some embarrassment?
Well, they don't say it with any embarrassment, but the Attorney General has taken a very clear position that he believed that these minor modifications that the department issues are ephemeral. They're momentary, they don't have any binding effect. That is the position. Now, having said that, as I said, I've done a lot of real estate development projects, and we routinely apply for minor modifications. Sometimes we record them because the regulations are abundantly clear. They're binding. They're just like any other permit. It is a remarkable position, right? It's remarkable because you say of all the things you would try to do and all the problems we have for public access to waterfront development, what we're going to choose to do is engage in endless litigation, appealing a case that they lost at the Superior Court level, right? To try to achieve a result which would be inequitable, right? I mean, Commonwealth decides to kick out dozens of property owners on the ground floor, removing them of their life's investment.
Is there a briefing scheduled in the appeals court right now?
We just received the appeals court, the Commonwealth's brief yesterday. Yes, so there's reply briefs that we have.
Oh, can we see that?
Commonwealth brief next month.
Can we see that online? I'm really
I'll
curious.
send it to you, I have it.
Okay,
when's the hearing date?
We're having it
Or
ready.
the hearing for
The
special
state house hearing
legislation?
is October
Oh,
29th.
the legislative hearing is October 29th.
Okay, October 29th.
For natural resources, environment.
What is that? Oh, that,
Natural resources.
Yeah, I have it, I can send it to you.
perfect. And so if people are, if individuals in the neighborhood are looking to send letters of support or to assist with this special legislation.
The hearing's public.
who would
Yeah,
they-
I'll send it to you. I have the committee.
Do we have an email or is it?
I have email addresses of the committee chair. It's a joint committee.
Okay.
So I have their addresses. And Senator Balcori and Representative Leibowitz and Councilor Edmonds, they're all working with us.
Okay. So I believe that we were under the impression that we weren't taking a formal public vote on this today. Is this something that we could table and discuss?
I'd
as
like
a-
to make a motion to vote tonight as a
And
council.
I second that.
So, I mean, that's obviously a motion and second, but just, I mean, I work at the State House, so I don't think, I would have to abstain from this particular issue.
Yeah.
So,
I'd have to abstain as well.
but I don't know how that impacts the vote. And I know we don't have a full council, so, I mean,
What's your quorum?
it's a simple
It's a majority. One, two, three, four.
Has anyone else conflicted out with you or anything with this, Joe?
I mean, yeah, see, this is the issue. Call it. So if you, I don't even know if we can take a formal vote on it. Do we have a copy of our laws?
Yeah, the hard copy, Joe. You have one here.
But, hang on.
Well, how many, so who's conflicted out besides me and you? Is that, are you two actually too? No. You
Not as a resident of the building?
Why would it, but it's not impacting my unit, yeah.
No.
It doesn't impact you? No.
Okay, no, I'm just asking.
I don't live on the first floor, so.
Well, we have a motion and we have a motion a second, so.
I just, but, I mean, we also, not, I mean, I'm not, listen, obviously no one wants to evict anyone. I don't think anybody's gonna be in favor, but we also haven't heard from anyone in opposition, which we usually do too, you know?
That's right.
So, I mean, I get that we have
I understand.
a motion and it's seconded, but I'm hesitant to, I'm abstaining, obviously, but I bring that up attention to the motion, you know, I don't know if that's, if we want to set that as a precedent, and perhaps we could adjourn or table that motion and then talk amongst a full council, we could bring in the other people and maybe do that off-site, would that be more, I mean, Tanya brought the,
You guys, would you like a vote from us either way, or would you
Whatever
prefer
you think is
a
right.
letter?
Whatever, whatever you think is right. I mean, we don't want to, whatever you think is the right thing to do, you know, form or however you want to do it. I'm not quite sure how you guys vote and all of that, but whatever you think is appropriate, you know, as individuals, you can write letters too, I mean, however you think, however you feel, it works best. But we appreciate your time.
Yeah.
And we appreciate your support.
That's the whole point was getting the information out there to the public. If-
Yeah, exactly.
Who to send letters
Let
to,
people know.
if the council wants to
Yeah.
send letters as a council or as an
Yeah, you can
individual
let
on
us
an
know.
individual
Yeah.
level, everyone can feel free to do it.
Absolutely.
So,
Tanya, would you be willing to rescind your motion then so that we can adjourn and then talk about it as a council for the letter in support of opposition?
If we write a letter, if we come to a conclusion and we write a letter as a council.
Right, correct.
So basically an offsite vote.
Yep.
Council.
Yeah, just to talk amongst ourselves and bring in other people involved that aren't here.
That's fine.
yeah, it's not a vote to approve anything, it's a vote
Yeah,
for
yeah.
endorsement.
Be helpful.
Yeah,
Said-
endorsement vote, sure.
Sure.
Yeah, I have the attorney general's,
Yeah, we have to be able to really come and respond to it.
Yeah, we,
30 days.
yeah. Well, so you won't get ours for.
I will say, I'll comment, I frankly have not gone through the entire brief yet, I'll look at my partner's letter. it doesn't get to the central issue. I mean, as for sure, as Fran understands, focused on this issue. It was a 30A administrative appeal, and the Superior Court judge basically said that the Department of Environmental Protection in this case committed a fundamental error of law.
Who's the judge?
Rashidi, who's a relatively new judge, used to be in the U.S. Attorney's Office, a fundamental error of law. And what the department, what the Attorney General's offices are truly procedural issues like, well, there was enough due process involved, there might have, a few people might have had actual notice that even though the Commonwealth refused to follow the process properly, they weren't fundamentally, they fundamentally did not lose their property interests or rights in due process, but they did not address the question, the fundamental questions of interpretation of a minor modification, or whether in fact, if I'm going to come to your, if I'm going to basically say as a condominium unit owner, I have the right to basically deprive you of your right to use your unit, occupy your unit, because of something that someone else may or may not have done down the hall or upstairs. Of course, it was sort of.
Are there title insurance policies for all units involved, all of them?
There are title insurance policies, but not all title insurance policies are going to cover these kinds of regulatory issues. But
There's no use for your unit that would qualify for something.
there are some compliance with law exceptions on some policies, but it's an issue that's been examined. Now, at the moment, just to clarify, all the department's case is about now is to say, you've got to get a license. So, as Cheryl said, and as the Attorney General's office said disingenuously in court, well, they've got to apply for a license. Let's see what happens. If they apply for a license and we deny the license to stay in their homes. But, you know, certainly, this is not a secret. I mean, enough people have heard about the fact that the Commonwealth has expressed, the DEP has expressed their intent to require that the units be vacant, that they be converted from residential to non-residential uses. It has been expressed in their
And that means not an office.
That's not true.
So the real
If
estate
they be
officer
facilities
has
of public accommodation, they would have to be,
quite a few offices.
there are some offices, they would have to be retail uses, retail restaurant uses, or presumably hotel uses, I mean, I suppose, lodging, if that's feasible.
Now, do we have an understanding why the harbor walk was not built?
I don't know why, I think he just basically took the money and ran.
The developer did not secure permission for the water sheet from the owner of the marina. They were building some of it on Commercial Wharf's land, association's land, and some over the water. And he never put the money in escrow. And the DEP, as far as we know, never asked for it.
So one of the things I'll mention, the harbor walk that we are proposing is on the wharf. The original developer's proposal was to cantilever it out over the water sheet so that it wouldn't necessarily impact the use of the wharf property as much. That ship has effectively sailed, so instead the condominium association is proposing to squeeze the harbor walk in along that southern edge.
Yeah, we have plenty of them.
So, without further, I mean, if we can just try to wrap it up a little bit here right now. So, with that being the case, Cheryl, you said that you could email us the contact for the letter. Is there a way that you can, Matt, would that be also beneficial to you so that you have it online for your website to post as well?
I have it already, thanks.
You already have it?
Yeah.
Okay.
I have the emails and the names.
Okay, excellent. So if we can coordinate that and make sure that all the residents in North End are aware, if they're interested in supporting it, if they'd like to voice support,
Yep.
please acknowledge it.
Thank you. Thank you very much.
Thank you, Cheryl.
Really appreciate
Thank you
your
very
time.
much. Appreciate it.
Thank you.